All rise. We will away. Please be seated. We will as well.
Yes, just before I give the various rulings, one thing I did miss out was really to do with items relating to victims. Firstly, the VPRS and mapping reports. And the question of household forms as opposed to individual ones, as well as victims in pre-trial. Now, we had in mind, and I just want to hear at this stage if there's any objection to make various orders, really for the VPRS to file a report including the possibility of having a mapping report and household forms. The main mapping report to be filed 30 days after the Article 74 judgment. I see Mr. Ambach indicating assent, I think is the polite way of putting it.
Assent.
And next we were going to authorise the use of household forms in addition to individual application forms, unless there's an objection. If there isn't, then we'll authorise it. If there's an objection, we're not going to make a ruling, and you can make submissions from my side.
Thank you, Madam President. As far as we are concerned, we would prefer to maintain the individual. As far as we are concerned, we would prefer to maintain the individual form and the household form, so that victims can choose which one, because on occasion, some victims would like not to complete a household form because some members of their family may not be aware of what happened.
Right.
So we would prefer to maintain both options. Thank you very much.
Right. Well, is there any objection to this? If no, I see Mr. Haynes shaking his head. I see Mr. Nichols shaking his head. Right. Then we will authorise the use of both forms, Ms. Masida. And finally, we were going to order that the victims who participated in the pre-trial proceedings are authorised to continue participating in the trial proceedings. Any objection to that? No. Okay, well then we make that order as well. We didn't mention, but I'm going to mention now this, that pursuant to Regulation 37 of the regulations of the court, we're going to limit parties, participants and registry in their written submissions to 12 pages, which is what we did in Al Rahman. If you, for some reason, want to add to that limit, you must apply for permission and explain why. As far as further submissions are concerned, we're going to hold 2 more status conferences. We would prefer that unless there is something that needs urgent resolution, submissions are made at those status conferences so that they can, if at all possible, be dealt with orally. But as I say, if there's something really urgent, then of course you can file a submission. Right, it was brought to my attention next, before I deal with the rulings, that I wasn't altogether clear this morning about the question of protocols to be used. So I'm going to now read out what we say about protocols. As a general rule, the Chamber will use the protocols that are already in place in the Chamber's manual. As I've already indicated, Chambers will allow witness preparation. The registry is instructed to file in the record the witness preparation protocol, the familiarization protocols as used in the Al-Rahman case, which mirror those in the model conduct of proceedings. The registry is to liaise with the parties and participants and report back to the Chamber on the proposed use of dual status, vulnerability and redactions by the 15th of June of this year. If changes are foreseeable to the e-court protocol, the registry is to liaise with the parties and report back to the Chamber with a proposal, particularly as regards submission of evidence during the course of the trial by the 15th of June. Right, I hope that yes, sorry, and I forgot to say that the cut-off, no, I was about to say that actually, but anyhow, the cut-off date for any applications from the victims to participate in the proceedings is the end of the prosecution's presentation of evidence, and we will follow the ABC participation approach. Right. As far as the fitness, the assessment of the fitness of the accused to stand trial, what we decided to do is that in the light of the short discussion, it would be preferable if the parties could liaise together and prepare a proposed joint letter of instruction. We were going to do it ourselves, but then we thought that you might then want to object, so it's probably simpler if the two of you can come to an agreement. We would like that, please, by Friday of next week, which is the... actually, no, I think we said a week today. What's a week today? 3rd of June. Yeah.
Wednesday.
Yeah, sorry, my fault. Not Friday. Wednesday, the 3rd of June. And registry, we would be grateful, please, if you could contact the experts immediately to check on their availability and let us know by the end of the week. That's the 3 experts who saw him before. Right, as regards, first of all, then to the decisions we've come to, the start of trial, we are prepared to accede to the prosecution's application of the 30th of November as the start of trial. The trial will run on a daily basis until the judicial recess, or thereabouts. We have to wait for the report on the accused's fitness, and they will specifically be asked to, if they find him fit to stand trial, about the proposed sitting. The Chamber would obviously like to sit, subject to witness problems, 5 days a week. But we note the recommendations that were made for the confirmation hearing, and so it may well be that we'll have to adjust it if we have to have a day for the accused not to be in court. each week. That doesn't necessarily mean it won't be a sitting day, because we can use that day to deal with any administrative matters or any legal arguments that are due to take place, subject, of course, to the accused waiving his right to be present. So effectively, at the moment, as I say, subject to what reports we get, it should be taken by all participants in the registry, that we will be sitting continuously until the recess at Christmas. We very much also urge the registry to make the necessary arrangements so that for the opening statements at the end of November there can be interpretation, even if there isn't a sufficient pool of interpreters for witnesses. I think it's important that opening statements can be understood by those in the Philippines. Right, so the deadlines for the prosecution in the lead-up to trial. The prosecution provisional list of witnesses and evidence by the 29th of June. Its trial brief, final list of witnesses, and list of evidence relied upon in the trial, 31st of August, which is 3 months before the trial. And the same deadline, that is the 31st of August, applies if you wish to add new incidents. Plus the list of experts, and appreciating the difficulty sometimes in getting experts to provide reports. We would like as many reports as are available, and if a report isn't available, then at least a summary of what it is expected that the expert will be saying in his report. Any evidence disclosed or to be added to the list of evidence after that date is strongly discouraged and will be subject to the Chamber's authorization, good cause to be shown, with a full explanation for the reason for the delay. Simply a reminder that disclosure of exculpatory evidence and Rule 77 should be done on a rolling basis. After our discussion this morning, review your evidence to make sure that we avoid having repetitive, irrelevant, or over voluminous evidence. And as already discussed, the witnesses interviewed under Rule 55, the schedules that we discussed and which are familiar to you from the Al-Rahman case. As far as pretrial motions are concerned, if there is any issue that needs resolution before the start of the proceedings, pursuant to Rule 134, 1 and 2, again, cut-off date 31st of August. I'll give you the dates of the status conferences in a moment, but we will deal with them all, I hope, then. And of course, obviously, if it's urgent, that's a different matter, and it should be filed as soon as possible. The dates for the next status conferences between now and the summer recess are the 23rd of June and the 14th of July. As indicated this morning, the defence's indication of issues and defense to be provided by the 30th of October. The legal representative of the victims' trial brief, 28th of September. As far as agreed facts are concerned, we're not going to set a deadline, but we will review the position at each of these status conferences. We echo or repeat our hope that you can reach a substantial number of agreed facts. Having considered Ms. Masida's representations, the LRV can receive notification of what facts have been agreed and can make submissions on this, which the Chamber will consider. As far as the conduct of proceedings is concerned, I've mentioned some matters. There will be other matters dealt with in that. Effectively, it will be it's intended that it will very much be the same model as that in the Al Rahman case, which also models the Model 1 in the Chamber's manual. But if anybody wants to suggest amendments to it, they must do so by Friday, the 5th of June, so in other words, next Friday. I mentioned this morning that we were thinking of trying to find a balance between the submission and admission process. But I'm reminded I think that the conduct of proceedings and indeed the Chamber's manual states that where there are documents which the Chamber or the parties consider are important ones, it can be, whether or not it will be admitted, can be dealt with at the time that the document is tendered. But I really do emphasize we don't expect to be drowned in documents. So those are the rulings, unless anybody thinks I've missed anything out that I said I'd give a ruling on. And unless there are any other matters, that concludes to the status conference. Nobody got any other matters? No, right. Yes, thank you all very much.
All rise. We will agree.